Hello and welcome to Sundial's North Yorkshire's talk about how to appeal the local authority's decision to refuse to issue an education, health and care plan after they have carried out a needs assessment. These slides are going to take you through the who's, why's and what's of this process, how to complete the correct form and what the next steps are. So what does a no to issue mean? It means that you, as a parent or young person over 16, or the school, have put in a request for an educational, health and care needs assessment. The local authority have carried out a needs assessment and then have considered whether they think a plan is necessary and decided that it isn't, so they're not going to be issuing one. They will have used the SEND Code of Practice Section 51 when making this decision. Having accepted that the child or young person does have special educational needs, the local authority have decided that these needs can be met by a mainstream school using the resources typically available to them. The law relevant to this is the Children and Families Act 2014, Section 66, which states that all schools have a best endeavours duty to meet the needs of pupils with special educational needs. This includes resources, staffing, specialist advice, for example from the SEND Hub, and reports from professionals such as an educational psychologist. It also refers to the delegated budget that all mainstream schools receive for providing support for special educational needs. Although not ring-fenced to any specific child, the local authority may say this should be used by the school for any reasonable adjustments or additional and different provision. The term additional and different comes from the SEND Code of Practice, sections 9.53 to 9.56, and also 9.57 to 9.59. At this point, the decision must be led by the needs of the child or young person. The cost of providing any provision over and above that delegated budget should not be a factor. We do get feedback from some parents that say the school has suggested that their child would not get an education, health and care plan because they are too academically able. There is an urban myth that assumes that if a child or young person is attaining at or close to age-appropriate levels, then they cannot have special educational needs. This is not true. As the slide says, some learning difficulties and disabilities occur across the range of cognitive ability. For example, many of the areas of difficulty that fall under the umbrella term neurodiversity, such as dyslexia, dyspraxia, ADHD and autism, and other disabilities, such as cerebral palsy, would fall into this category. Section 51 of the Children and Families Act 2014 contains the right of appeal against a refusal to issue a plan. Subsection 1 states that a child's parents or a young person may appeal to the first tier tribunal against the matter set out in subsection 2, subject to mediation. Subsection 2 states that the matter to be appealed is a decision by the local authority following an educational healthcare needs assessment that it is not necessary for special education provision to be made for the child or young person in accordance with an EHCP. The notification or decision letter sent out by the local authority is really important. It gives you your right of appeal, and the tribunal service will need to see sight of it before they will register your appeal. It also sets out the time frame for the appeals process. In addition, if you decide to go for mediation, which we will look at in a moment, the mediation service will need to see sight of the letter before they can go ahead. Some parents, carers and young people may be eligible for legal aid. If you are entitled to legal aid, then funding can be provided for a solicitor to prepare your case, and in some cases to pay for assessments, which then can be used to provide further evidence to the SEND tribunal. You can find further information on whether you qualify for legal aid by contacting the Civil Legal Advice on 0345 345 4345 or looking on the Civil Legal Advice website. For this slide, it may be useful to look at some definitions, such as who is classed as a parent or carer. The Children Act 1989 gives a definition of parental responsibility and says only those with parental responsibility can make decisions that impact the child or a young person if they are 0 to 18 years of age. However, SEN law has an additional part which widens parental responsibility to include others like carers. So within this law, we treat it as the person the child of 0 to 16 years lives with for the majority of their time. The Education Act 1996, Section 576, defines a parent to include anyone who has care of a child, even if they do not have parental responsibility. This would apply to foster carers. For young people, the definition is from the last Friday of June of the young person's 16th year, so at the end of year 11, the young person is able to make their own education, training and learning decisions within special educational needs, but they can ask a parent or a carer to advocate for them. As I said previously, the notification letter from the local authority sets out the timeline for the appeal. The deadline for appealing is 2 months from the notification letter, or if you decide to go for mediation, it will be 1 month from that meeting. Let me try and explain by giving a bit of an example. Harry received a notification letter from the local authority advising him that they were not going to issue an EHCP for his child. The letter is dated the 16th of April. Harry doesn't agree with the decision and wants to appeal it. The deadline for the appeal to be lodged is 2 months from the date of the letter, which in this case would be the 16th of June. However, Harry decides that before lodging the appeal he would like to try mediation. He contacts the mediation providers and they arrange a date for it. The date of the meeting is the 29th of May. This means the deadline for lodging the appeal, if the mediation outcome is not what he had hoped, is now the 29th of June, so it has been extended. If the meeting was going to take place before the 16th of May, then the original deadline would still be in place. I hope this makes sense. Although there has been some discussion in government about whether or not mediation should become statutory, you currently still have a choice. So if you feel that a conversation with the local authority with an impartial mediator present will be of benefit to your case, mediation may be for you. If, however, you feel you've had plenty of conversations with the local authority and don't feel that another one is going to change anything, all you need to do is request a mediation certificate. The company that currently is commissioned by the local authority to provide mediation is Collis Mediation Limited. You can find out more about what they offer and the mediation process by going on their website. You can also find further information on our website, Sendias North Yorkshire. We also have a 1-minute guide with audio titled How to Request Mediation, which is a guide to completing the Collis online form. For any type of appeal, you need to complete the correct form. For a refusal to issue appeal, you need a SEN 35 form. All the forms you need for an appeal can be found on the www.gov.uk website. Type Sendist Forms in the search engine and it will bring up a list. Simply scroll down the list until you find SEN 35, which is the right form for refusal to issue appeal. Did you know that there are videos on YouTube that tell you how to complete a SEN 35 form? The slideshow shows the URL address, which you can copy down if you want to, but you can also find the videos by searching for Suffolk Sendias in the YouTube search box. So thank you to Suffolk Sendias for these and making them available for everybody to use. When you have downloaded and completed the SEN 35 form, you need to send it, together with any evidence, to send@justice.gov.uk. So that's lowercase send at justice.gov.uk, again all lowercase. You may need to send more than one email, as the HMCTS, His Majesty's Courts and Tribunal Service mailbox, has a limited size. You will receive an automatic response acknowledging receipt of your email or emails. After 2 to 3 weeks, you will receive your registration documents. These will include a new registration document, an NOH or Notification of Hearing document, a SEN 45, which is a case review form, new bundle guidance, and guides how to do e-filing and how to send emails to the Tribunal Service. The Notification of Hearing gives all the crucial dates for the process right up until the hearing date, and this will enable you to plan for the next steps. As I mentioned, we do have our own website, but there's also EHC, the independent providers of special education advice. The website is excellent and has a lot of advice and free resources on it. On their homepage you can see how we help, and when you click on this you will see a drop-down menu giving a quick overview of what they offer. There is also a search engine on their page, and if you type in refusal to issue information pack, it should take you to where you can locate it. We hope that you found this information useful. We would welcome your feedback. If you need to get in touch, you can see the details of our email and phone number on the slide. Another really useful way is to use the contact form in our Contact Us section on the website. It enables you to give key information that will enable us to tailor our advice to your needs. Thank you for listening.